Okay. So Dr. H. Fadl is a full professor at the Faculty of Law, which he joined in January of 2006. Professor Fadl wrote his PhD dissertation on legal process in medieval Islamic law while at the University of Chicago and received his JD from the University of Virginia School of Law. Professor Fadl was admitted to the Bar of New York in 2000 and practiced law with the firm of Sullivan and Cromwell, LLP, in New York, New York, where he worked on a wide variety of corporate finance transactions and securities related regulatory investigations. Professor Fadl also served as a law clerk to the Honorable Paul V. Namer of the United States Court of Appeals for the Fourth Circuit and the Honorable Anthony A. Alamo of the United States District Court for the Southern District of Georgia. Professor Fadl has published numerous articles in Islamic legal history and Islam and liberalism, and he was gracious enough to um, take time out of his day to teach us a little bit about history of Palestine. So if we could just give him a little round of applause.
Thank you, Janine. I also should have mentioned in my biography that I have been teaching a class on the law of Israel and Palestine with an Israeli colleague for the past 3 years. We started it in the fall of 2023, just out of sheer coincidence. Um, One of the reasons why we did so was because we had a hiring scandal at the University of Toronto Law School around 2020 or 2021, when there was an attempt to hire a woman to head up our international human rights program, and that hiring attempt was scuttled by a Zionist alumni who somehow got news of the potential offer to the candidate and intervened through advancement at the university and had the appointment terminated. I don't want to get into all the details of that, but one of the things that my Israeli colleague and I decided to do in response to that intervention was to begin teaching a class on Israel and Palestine for lawyers. And so my presentation that I'm about to share with you is based on, in large part, on the research that I did for that class. And I've published 2 law review articles, again, out of that work. And one of the things that I found interesting, as if you're listening to Janine's introduction, I'm professionally a corporate lawyer. That's where that's when that's what I did in private practice. I was on Wall Street. I did lots of the kind of work that you would imagine a corporate lawyer does. And then I also a legal historian of Islamic law. And even as somebody who's always been actively committed to Palestine since I was as old as I can remember, I just learned a lot by teaching this class because I never studied Palestine from a legal perspective. And what's shocking, although this shouldn't be shocking to us, is how utterly bereft of any basis in law the Zionist project has. And that's why it's so violent. Um, because when you lack any legal legitimacy, the only thing you have is violence. Just like a thief, the only thing they can do is double down with violence because they have no claim of right. So what I'm going to focus on is the place of Palestine in 20th century international law, because it's something I think that most people don't realize. And this is one of the things I think where Zionism has been extremely successful, namely convincing us that law is irrelevant. And what I want to do is center the legitimacy of law. And this should be our first weapon. And we always point out to people that Palestinian claims are always based on right. Zionist claims are always based on violence. So do you see my slides? Yeah, okay, great. Okay, so Palestine, 20th century public international law, and the sacred trust of civilization. To understand the place of Palestine in public international law, you have to go back and begin with, um, sorry, uh, with the end of the 19th century. So at the end of the 19th century, we began getting some major instruments of international law regulating combat and the consequences of occupation. Um, Prior to then, the assumption was that when one state acquired territory of another state, they obtained what was known as the right of the conqueror. As the conqueror, they could sort of do whatever they want with the territory and the people on the territory. Now, you can imagine that such a doctrine flies in the face of self-determination. Now, the doctrine of self-determination as a fundamental human right had not fully crystallized even by the late 19th century, even in Europe, even in the case of Europe. Of course, this was also the age of high imperialism. But at least among the so-called civilized states, right, there was this conception that simply acquiring or occupying the territory of another sovereign did not give the occupying power sovereign power, i.e., the legal right to control and make changes and legislate for the people on that territory. So this is reflected in the Hague Convention with respect to the laws and customs of war, signed July 29th, 1899. As you know, it says the authority of the legitimate power having actually passed into the hands of the occupant, the latter, meaning the occupant, shall take all steps in his power to reestablish and ensure, as far as possible, public order and safety, while respecting, unless absolutely prevented, the laws in force in the country, right? And the reason for this is because it was recognized that if the occupying party would attempt to change the laws, they would be ignoring the rights of the inhabitants, right? So you can see this idea of self-determination at play in this principle that an occupying power had to respect the laws of the place that it was occupying, right? Now, this is the important point with respect to Palestine. Before World War I, both Great Britain and the Ottoman Empire were parties to the Hague Convention, right? And when Great Britain occupied Palestine in 1917, right, it was subject to the rules of the Hague Convention, meaning that Great Britain had no authority to change the legal status quo in Palestine, right? Palestine continued to be, from the perspective of international law, occupied our Ottoman territory, occupied territory of the Turkish Empire, right? Whatever you want to call it, until the end of the war. And as I will get to, the Treaty of Lausanne was ratified, right? I'll get to that in a second. Now, in the meanwhile, World War I came to a conclusion with respect to Germany and the Austro-Hungarian Empire, at least, with something known as the Covenant of the League of Nations. That was signed on June 28, 1919. This is a very important document because it represents the most fundamental peace agreement that brought the end of World War I, right? And it deals with the territories of the former Ottoman Empire. As you may know, the Ottoman Empire included what is today Turkey, but it also included much of the Arab world, right? And so Article 22 of the Covenant of the League of Nations provided the following. To those colonies and territories, oh, sorry, let me back up. Part of the struggle in World War I, at least from the perspective of the United States, right? The United States entered World War I in 1917. And the United States entered World War I pursuant to Woodrow Wilson's 14 points. One of the points of Wilson's 14 points was the principle of self-determination of peoples, right? And in his 14 points, he made an express commitment that the peoples of the Ottoman Empire should be granted self-determination at the end of the war, right? And so this is reflected to a great extent in the Covenant of the League of Nations, which says at the beginning in Article 22 that to the extent that the defeated Central Powers are losing their colonies, right, and they will now be administered by the victorious Allied parties. They will not be administered as colonies as such that would allow the victorious parties to do with them whatever they wish, but rather that the Allied parties will become administrators of these territories, will sort of be acting as, to put it colloquially, their big brothers, sort of helping them get on their feet so they can govern themselves in the modern world under the principle that, quote, the well-being and development of such peoples form a sacred trust of civilization, right? So despite the hypocrisy involved in European powers' commitments at the time, this is very important because it signifies a de jure repudiation of the age of colonialism and imperialism. That from now on, the colonial powers are going to work toward the progressive realization of the independence of the people under colonial rule, okay? And that the former territories of the Ottoman Empire, the German Empire, and the Austro-Hungarian Empire will be subject to these principles. Now, Article 22 also had very specific provisions about the former territories of the Ottoman Empire. As you recall, I mentioned that Woodrow Wilson promised in the 14 points that the peoples of the Ottoman Empire would be given unmolested freedom to self-determine at the end of the war. So Article 22 kind of satisfied that. It said certain communities formerly belonging to the Turkish Empire have reached a stage of development where, quote, their existence as independent nations can be provisionally recognized, subject to the rendering of administrative advice and assistance by a mandatory until such time as they're able to stand alone. The wishes of these communities must be a principal consideration in the selection of the mandatory. Now, this is in reference to the mandate system. It's very important to understand that the mandate system, from the perspective of public international law, was not the equivalent of colonization. It was more along the lines of a trusteeship. In other words, the mandatory power exercised governance, the responsibilities of government as a trust for the benefit of the governed peoples. Now, in the particular case of the peoples of the former Ottoman Empire, the Article 22 of the covenant recognized that they were basically ready for independence immediately. The only thing they needed was what the treaty calls administrative advice and assistance, right? So this was sort of like dotting the I's and crossing the T's, but essentially the former provinces of the Ottoman Empire were recognized immediately at the end of World War I as independent nations from the perspective of public international law, right? That gave them a very different status than the other kinds of mandates that were set up under the Covenant of League of Nations. So international law scholars talk about Article 22 creating three classes of mandates: Class A, Class B, and Class C. So the former Ottoman territories were considered Class A because they were recognized, their provisional independence was recognized immediately. Now, the treaty that ended the war, World War I, between the Allied powers and Turkey is known as the Treaty of Lausanne. That came into effect on July 24th, 1923. Now, that's important for a couple of things. Until that treaty came into effect, Great Britain, from the perspective of international law, continued to be an occupying power in Palestine, meaning it did not have authority to make any changes in the legal system. They had to respect the legal status quo, and they had to enforce Ottoman law throughout this time, according to the Hague Conventions, right? It was only upon July 24, upon the peace treaty between what's now the Turkish Republic and the Allied powers, could the mandate for Palestine, which I'll talk about a little later or shortly, come into effect. Until then, Great Britain only exercised power as an occupant, which required it to respect the status quo. In any case, the Treaty of Lausanne has some very, very important provisions with regard not just to Palestine, but all former territories of the Ottoman Empire. The first has to do with nationality. So nationality is basically your status in international law, right, as a member of a state, okay? And so it says, prior to the Treaty of Lausanne, all persons in the Ottoman Empire were Turkish nationals, Ottoman nationals, right? And so the treaty has a section on citizenship, on nationality, right? And it applied this principle known as ipso facto nationality. Ipso facto, what this principle means is that if there is a change in sovereignty, right? Like, for example, if Canada, just imagine, suddenly became part of the United States, okay? What would happen to our Canadian citizenship? Well, there's this principle in international law called ipso facto nationality that applies when there's a change in sovereignty. According to this rule of public international law, whenever there's a change of sovereignty, the people take on the citizenship of the new sovereign automatically. Nothing, they don't have to do anything. They automatically get nationality of the new sovereign. And so the treaty reflected this. Article 30, Turkish subjects habitually resident in territory which in accordance with this treaty is detached from Turkey will become ipso facto in the conditions laid down by the local law, nationals of the state to which such territory is transferred. Okay? So this treaty confirms two things. First of all, that when Turkey or the Ottoman Empire gave up these territories, they did not give them to Great Britain as colonies. It confirms that they are being detached from Turkey as states, so that all the different states that are coming into existence in following World War I are actual states. They are not colonies of Great Britain or France. Okay? The second is that they are entitled to citizenship in the states in which they are habitually resident by virtue of this treaty. So whoever happens to be in Lebanon, whoever happens to be in Syria, whoever happens to be in Iraq, whoever happens to be in Palestine, whoever happens to be in Jordan, they are entitled as a matter of international law to citizenship of that state because it is being detached from Turkey, right? Article 31 then deals with the situation where people, let's suppose somebody in Palestine or Syria or Lebanon or Iraq doesn't want to be Palestinian or Lebanese or Iraqi or Jordanian, right? They have the right to opt for Turkish nationality, okay? So this is a very important principle in public international law that when ipso facto nationality applies, it could seem like it's interfering in the freedom of the citizen. Like, suppose I don't want to be a US citizen if Canada becomes part of the United States, right? Well, I have the right to opt out of it and continue being a citizen of my previous country, right? Let's say the United States just took over Alberta or something, right? I could still say, you know what, I don't want US citizenship. I want to remain a Canadian, and then I can leave Alberta and go to Ontario. Okay? That's what Article 31 is doing. That there might be some people in the former Ottoman provinces that would prefer to stay with Turkey. That's their right. They're not going to be forced to accept the citizenship against their will. Okay. It also provided that if you are a racial minority, you could reject your new nationality and go become a citizen of another state where your race is considered a majority, right? And it also protected your property rights. That if you refuse the new citizenship, you have the right to leave with all your possessions intact. Okay? Now, as we know, or as we should know, as by virtue of the Treaty of Versailles, there's something called the mandate system came into place, and specifically the Palestine Mandate, right? The Palestine Mandate, Zionists often misconstrue as creating the basis for a Jewish state. Again, that is not true. It is Zionist mythology. The Palestine Mandate, all that it did was establish something known as the Jewish national home. A Jewish national home in public international law doesn't mean anything. It doesn't mean a state, right? As we saw in the language of, the Treaty of Lausanne, and we saw in the Covenant of the League of Nations, very specific language is included when referring to an entity as a state. The Jewish national home is clearly not a state, right? And there are many provisions within the Palestine Mandate that make clear that the Jewish national home is supposed to exist within Palestine, right? I.e., you could think of it as a sub-community or a subsection of, but existing within the state of Palestine. And that's clear because the mandate, including the mandatory power, Great Britain, while promoting the Jewish national home, is supposed to also promote development of self-governing institutions for Palestine and to guarantee the civil and religious rights of all the inhabitants of Palestine. Other important facts is that it is supposed to facilitate Jewish immigration for purposes of creating a Jewish national home, but while not prejudicing the rights of the other sections of the population. Right? It also prohibited alienating the territory of Palestine to any other government. So, for example, the British mandate, the mandatory government of Palestine, could not say, you know what we're going to do? We're going to give up half of Palestine and give it to Zionists to create a Zionist state. The terms of the mandate did not allow them to do that. It allowed them to facilitate a Jewish national home in Palestine, right? And then finally, Article 27 required the consent of the Council of the League of Nations to modify the terms of the mandate. This is very important because one might say, well, the British didn't really enforce the terms of the mandate and nobody stopped them. So that amounts to an amendment to the terms of the mandate. That's not true. The terms of the mandate expressly said that consent had to be, any terms of the mandate, any amendments to the terms of the mandate had to be by the official consent of the Council of League of Nations, which never happened. Right? Okay. By the way, you guys can stop me at any point in time to ask questions because some things I understand might be new to you or might be not clear to you. So I want to make sure that you get a chance to ask your questions. Another important development in international law was the Kellogg-Briand Pact of 1928. Prior to this treaty, again, conquest was a normal part of international relations. Aggressive war was not a crime in international law. A state, if it claimed territory belonging to another state, sort of like the Russia invading Ukraine, or Israel invading Palestine, they could just invade it, and if they had a better army and they won the war, they could take it and annex it. Okay, the Kellogg-Briand Pact of 1928 prohibited that. Right, so this was very important because it prohibited the use of war as a means to solve disputes between states. Okay, so you no longer could settle your dispute with your neighbor by conquering them. And this is one of the crimes for which the Nazis were convicted at the end of World War II, the crime of aggression. Okay, so as you can see, or as I hope you can see, there's a lot of important international law that came into existence at the end of World War I regarding Palestine. First, international law birthed Palestine. Prior to World War I, Palestine was just a part of the Ottoman Empire. By virtue of the peace settlement of World War I, Palestine became an independent state, albeit a state under a mandate. Right? So now I want to turn and speak to Palestine's existence as a state during the mandate. So the first thing I'm going to begin with is the idea of Palestinian nationality. So where does this come from? Well, we saw that the Treaty of Lausanne expressly mentioned the idea of ipso facto citizenship. Well, one of the first things that the British did once they became the mandatory power, and as we recall, they could only do this legally at the end of World War I, which with respect to Palestine was in 1924, they issued a citizenship order, i.e. rules about who is a Palestinian citizen. So the very first article of the citizenship order applies this principle of ipso facto citizenship. So it says Turkish subjects habitually resident in the territory of Palestine upon the first day of August 1925 shall become Palestinian citizens. Okay. Now, as a matter of fact, when that order went into effect, 99% of the people who were granted ipso facto citizenship were Arabs, almost entirely Muslims and Christians. So only 1% of the Ottoman population of Palestine, Ottoman citizens of Palestine, were Jewish. And of course, they received Palestinian citizenship under this principle, as was their right. The second article of the citizenship order dealt with native Palestinians who were residing abroad, because Article 1 only conferred citizenship on Palestinians who happened to be in Palestine on August 1st. Well, what happened if you were in the United States or in Canada studying or doing business or working? Well, it provides for that. Persons over 18 years of age who were born in Palestine, were born within Palestine, and on the first day of August 1925 are habitually resident abroad, may acquire Palestinian citizenship by opting in such manner, subject to the consent of the government, which may be granted or withheld in its absolute discretion. So basically, this said was if you were born within Palestine during Ottoman rule, and you went to the United States or Canada as an immigrant, and you were habitually resident there, it may very well be the case that you've immigrated from Palestine. So therefore, you're not entitled to ipso facto citizenship. If you want ipso facto citizenship, you have to apply, right? Because you're no longer resident here. But it preserved this notion that if you were born in Palestine and you wanted Palestinian citizenship, you could get it. The third article deals with citizenship by birth. So it says if you are born in Palestine to a Palestinian father in a lawful marriage, i.e. a legitimate marriage, then you get Palestinian citizenship. And if you are born outside of Palestine to a Palestinian father, whether he's a Palestinian by birth or naturalization, you are also a Palestinian citizen. And then finally, you're born in Palestine, whether in or out of a lawful marriage, but you lack any other nationality or your nationality is unknown, right? So if your parents are living in Palestine as of August 1st, 1925, and they give birth to you, and they are of unknown nationality, nobody knows what their nationality is, then you are given Palestinian nationality. Or you're the product of an illegitimate birth, right? Your father is unknown, but you're born in Palestine. You too would be given Palestinian nationality. Right? So it's very clear that the British created Palestinian citizenship pursuant to their obligations under international law, and anybody who had a real connection to Palestine, right, through birth or through or residency, was given Palestinian citizenship. Okay? Now, what about immigration? One other thing. You could also become a Palestinian citizenship if you were born in Palestine and you had Turkish nationality and you still possess Turkish nationality, but you were abroad, right? So let's say you were born in Palestine and then you, before World War I was over, you moved to, for example, what's today Turkey or Egypt, right? Now, you could also become a Palestinian. All you had to do was come back to Palestine and live there for 6 months. The condition is you couldn't have acquired another nationality while you were abroad. So obviously this wouldn't apply if you were born in Palestine and went to another area within the Ottoman Empire, but it would if you had gone to France, England, etc. Okay. In any case, as I'm showing, the 1925 Citizenship Order was pretty comprehensive in preserving the rights of Arabs in Palestine to Palestinian citizenship. Okay. How did naturalization work in the mandate? Well, first of all, it should be clear that this naturalization regime was instituted to facilitate Jewish immigration to Palestine. But it was not limited to Jewish immigration. Anybody could immigrate to Palestine and become a citizen of Palestine, provided they met these conditions. And what were these conditions? They had resided in Palestine for a period of not less than 2 years out of the 3 years prior to the application, have good character, and has an adequate knowledge of either English, Arabic, or Hebrew. Again, this whole naturalization law is completely inconsistent with the idea that the mandate of Palestine was to create a Jewish state, right? If it were to create a Jewish state, then why would you allow Arabs to immigrate to Palestine and become naturalized citizens? In any case, what did a naturalized citizen swear to when he became naturalized? The oath of allegiance was, I swear by Almighty God that I will be faithful and loyal to the government of Palestine. Again, emphasizing the idea that Palestine was a unitary state and the Jewish national home was something not a state, right? Okay. Article 8 also tells us what the rights and duties of a naturalized Palestinian were. Quote, a naturalized citizen is, quote, entitled to all political and other rights, powers, and privileges, and be subject to all obligations, duties, and liabilities to which a Palestinian citizen is entitled or subject. Again, one common claim that one encounters among Zionists is that the Palestine Mandate did not only gave Jews political rights, that non-Jews did not have political rights. Again, the language in the naturalization order completely undermines that. In fact, it says that the only political rights that a naturalized citizen has is the rights which a Palestinian has, which makes sense. Because when I'm a naturalized Canadian, when I became naturalized, I get the rights of a Canadian citizen. It would be a very strange naturalization law in which naturalized citizens were given superior rights to, for example, native-born Canadians, right? And this is manifested in the certificate of naturalization that was issued upon somebody being naturalized. So the language on the actual certificate, which I will show you in a second, is this is what the naturalization officer would write. Now, therefore, in pursuance of the powers conferred on me by the said order, I grant to the said person, blah, 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 and declare that he or she shall be subject to all obligations, duties, and liabilities to which a natural-born Palestinian citizen is entitled or subject, and have to all intents and purposes the status of a natural-born Palestinian citizen. Again, reflecting the normal rules of immigration. When somebody is naturalized, it raises them to the level of the natural-born. It doesn't place them over the natural-born. So here's an example of an actual certificate of naturalization. This is the naturalization certificate of my colleague's grandfather, right? Now, I don't know if you can read this, but it basically says here, this certificate of naturalization and declare that he shall be subject to the provisions of said order, be entitled to all political and other rights, powers, and privileges, and be subject to all obligations, duties, and liabilities to which a native-born Palestinian is entitled or subject, and have all the interests and purposes, and have to all intents and purposes the status of a natural-born Palestinian citizen. Again, so this contradicts quite clearly the idea that the mandate for Palestine was intended to create a Jewish state for Jews at the expense of the Arabs. And this is the back of it, where the applicant for citizenship says, I swear by Almighty God that I will be faithful and loyal to the government of Palestine. And it says this in English, Arabic here, Hebrew, and English, right? Okay, any questions on any of this? Okay, so that is as a matter of internal Palestinian law. What about in international law, right? There's no doubt that during the interwar period, public international law recognized Palestine as an independent state. Not an independent state, as a state subject to a mandate, i.e. not yet independent, but a state distinct from all other states. So this is from the transcript of a hearing at the League of Nations, where it said Palestine was a subject under international law. While she could not conclude international conventions, the mandatory power, until further notice, concluded them on her behalf in virtue of Article 19 of the mandate. The mandate in Article 7 obliged the mandatory to enact a nationality law, which again showed that the Palestinians formed a nation and that Palestine was a state, though provisionally under guardianship. It was, moreover, unnecessary to labor the point. There was no doubt whatever that Palestine was a separate political entity, right? And so, again, the government of Palestine was a government separate from Great Britain. Great Britain exercised the powers of the government of Palestine for the benefit of the Palestinian people. And in that basis, Palestine entered into numerous international treaties. I will have an opportunity to mention some of those later on. But let's continue on with this idea of nationality. As you see here, the League of Nations emphasized the importance of the fact that there was an independent Palestinian nationality to confirm the fact that Palestine was a separate subject, a distinct subject of international law, right? That it was a separate political entity. We also have case law during the interwar period, in which it was established that Palestinian citizenship was exclusive, right? So it said the Palestinians and Jordanians, from a legal perspective, are foreigners, and therefore Transjordan must be regarded as a foreign state in relation to Palestine. Again, this goes to the heart of the Zionist argument that, oh, Arabs can just go to Jordan, or they can just go to Lebanon, or they can just go to Syria, or they can just go to Egypt, or they can just go to Iraq. Because in international law, each one of these are separate states. Palestinians, Arabs of Palestine, are citizens only of Palestine. They have no rights in any other state. Moreover, no other state has any obligation to receive them because they aren't citizens of that state. They are foreigners to that state, right? And so this was one of the incidents of the post-World War I legal settlement. Further proof that Palestine was a legal state in the interwar period is this case, the Mavromatis Palestine concessions. This is a legal case that was heard by the Permanent Court of International Justice in 1924. Now, the Permanent Court of International Justice is the antecedent to what the UN Charter calls the International Court of Justice. It pre-existed the International Court of Justice. Now, the important point that you have to understand is that only a state can appear as a party in a case before the Permanent Court of International Justice or the International Court of Justice. So this case involved two different concessions, commercial concessions, that the Ottoman government had given to a Greek national on the eve of World War I, right? And now the Greek government is suing Palestine, accusing the government of Palestine of having breached those commercial arrangements in the International Court of Justice. Now, if Palestine were not a state, this suit could not proceed. There would not be jurisdiction. So the very fact that this lawsuit took place is irrefutable evidence that Palestine was a state for purposes of international law after World War I, right? Now, again, going back to the Treaty of Lausanne, there's an express provision that reflects this. It says, in territories detached from Turkey under the Treaty of Peace, i.e. the Treaty of Lausanne, the state which acquires the territory is fully subrogated as regards the rights and obligations of Turkey towards the nationals of the other contracting powers and their companies. Now, subrogation is a legal concept. Basically, it means they step into the shoes of. So what this means is the state which acquires the territory detached from Turkey steps into the shoes of Turkey with respect to any rights that Turkey had or any obligations Turkey owed toward nationals of other contracting powers, i.e. other parties to the peace treaty, including Greece, right? So that means Palestine acquired all the rights and obligations of Turkey toward third parties. And that's what made this suit possible. Again, so this shows that Palestine had separate legal personality at the end of World War I. Now, I mentioned this idea of Palestine entering into international treaties. Now, you guys, I assume, aren't lawyers, but it shouldn't take a law degree to understand that only a state enters into a treaty. I can't enter into a treaty, right? You can't enter a treaty. Only states can enter treaties. So Palestine entered into several treaties in the interwar period, right? Again, further evidence of it being an internationally recognized person. Now, there's one treaty that I want to mention in particular, because it doesn't mention a treaty obligation of Palestine, but Palestine is the subject of a dispute, a trade dispute between the Great Britain and the United States. So in trade law, there's something called the most favored nation clause. The most favored nation clause basically says that whatever deal you give country A, you have to give me, right? So the United States, in its trade treaties with Great Britain, had a most favored nation clause, which basically obliged Great Britain to give the United States the same treatment that it gave anybody else. Okay. Now, Great Britain at this time, this is, I think, in the 30s, was preparing to lower customs duties with respect to exports from its colonies like India, right? And it wanted to reduce customs duties from exports of Palestine as well, right? Because they didn't want India to have a competitive advantage over Palestine for things like agricultural exports, okay? The United States objected and said, if you choose to lower the tariffs on Palestinian exports, then you have to reduce tariffs on the United States exports, because Palestine is not like India. India is a colony. From the perspective of international trade, that is internal trade to Great Britain. You can do whatever you want with respect to how you treat Indian commodities, because that's part of your internal commerce. But trade between Palestine and Great Britain, that is external commerce, because Palestine is a separate juridical entity. And so if you give Palestine favorable tariff rates, you have to give those to us too, right? So that again is powerful proof that Palestine existed as a separate state in the interwar period. Any questions? Yeah, let's move on. What about the United Nations? Did the United Nations upend this system? Well, actually, the United Nations Charter, if anything, strengthened the rights of Palestine in the international system. Under the first article of the United Nations, Section 2 says that the purpose of the United Nations is to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. Now, bear in mind that the right of the Palestinians, the right of the Arab people, the right of all the citizens of Palestine to self-determine was already recognized at the end of World War I. So this was not a new concession. This was confirming a right that had already been granted in 1919. Okay, but it would still not been made effective. I should have mentioned this in the first part of the presentation, the prior part. Unlike the other mandates, Palestine was the only mandate that did not achieve independence before World War II. All the other mandates quickly attained independence, right? Remember that the covenant of the League of Nations recognized that the former territories of the Ottoman Empire were provisionally independent, and that the mandates were just simply there for some technical assistance. And that's what in fact occurred. They very quickly achieved independence. So all of them had obtained their formal independence other than Palestine prior to World War II. Okay. Now, what else does Article 2 of the UN say? That all members shall settle their international disputes by peaceful means. It reiterates the the Kellogg-Briand Pact. All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, right? Palestine is a state. It says any state, not simply a member state, any state. Section 6, the organization shall ensure that states which are not members of the UN act in accordance with these principles, so far as may be necessary for the maintenance of international peace and security. Again, Zionists might say that, well, Israel was not a member of the United Nations, so it was not bound by the UN Charter. Well, that may be the case in 1948, but the rest of the United Nations were, right? The UN Charter bound them to respect and protect the independence of Palestine, right? And protect it from aggression and protect its territorial integrity. Finally, nothing in the present charter shall authorize the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state. Now, this is a provision that Zionists misuse. They try to argue that our treatment of Palestinians, whether Arabs should be citizens, whether refugees can return, et cetera, that is all a matter of our domestic jurisdiction, and the UN Charter does not authorize anyone to say anything about that. But as I will try to get to, that is completely false. Right? Okay. The UN Charter also had provisions on non-self-governing territories. Right? So recall that the Covenant of the League of Nations introduced this idea of the sacred trust, and that the new mandate system that was going to be established at the end of World War I over the former territories of the defeated Central Powers would not be one of colonialism, but that the interests of the inhabitants would be paramount, and that they would undertake those duties as a sacred trust of civilization. Right? This was reiterated in Article 773 of the UN Charter, which stated that non-self-governing territories must be administered based on the principle that the interests of the inhabitants of these territories are paramount, right? Important term, inhabitants, right? Not people living in distant lands that claim historical connections to that land, but rather the inhabitants of the territories must be paramount. And it reiterated this commitment that the states that are in charge of these territories are acting as trustees, not as owners, right? And that their obligation is to promote to the utmost the well-being of the inhabitants of these territories. How? By ensuring their political, economic, social, and educational advancement and their just treatment, to develop self-government, to take into account of the political aspirations of the peoples, and to assist them in the progressive development of their free political institutions, and to further international peace and security. Now, the UN created a new system, not called mandates, but called trusteeships. But again, the trusteeships would be motivated by the same principles to promote the political, economic, social, and economic advancement of the inhabitants of trust territory. Likewise, a trusteeship cannot diminish the rights, prior existing rights of people under some sort of mandatory system of rule. So it does not alter prior arrangements until the new trust system is put in place. Okay. So what happens with the so-called partition plan? Okay. Well, there are lots of reasons the partition plan was highly problematic. The most obvious one being its radically undemocratic nature. In 1947, Arabs represented 67% of the inhabitants of Palestine. But the problem went beyond that. Of Palestine's 15 or 16 districts, only one of them, Haifa, Tel Aviv, had a clear Jewish majority. Every other district had either an Arab majority or an overwhelmingly Arab majority, right? So if you look at Haifa, 53% Arab, 47% Jewish. Jerusalem, 62% Arab, 38% Jewish. Tiberias, 67% Arab, 33% Jewish, right? Et cetera, et cetera. So one of the problems in the partition plan, let me see if I can bring this up here. I'm going to go to a map on the web. Let me see if I might have to switch. Okay, see if I think it's opening slowly. Okay. Can you guys see this map? Do you see the map?
I don't see a map.
You don't see a map? Okay, hold on. Uh, okay, do you see the map now?
I see it now.
Okay. So this is a map of Palestine in 1947 with the distribution of the population. So as you can see, the only district in Palestine that had a Jewish majority was this area here, right? Everything else had vast majorities of vast Arab majorities, right? So this sort of what set up the problem, right? And not only that, let me go back to my slides. If you look at the distribution of property ownership, it's even more skewed in favor of Arabs over Jews. So if you look at Safad, 68% of the property is owned by Arabs, 18% by Jews. Akka, Acre, 87% Arabs, 3% Jews. Tiberias, 51% Arab, 38% Jews. Right? Even in Jaffa, Arabs own more property than Jews, 47% to 39%, right? So the objective conditions for having a Jewish state, at least the way the Zionists conceived of it, were not present in any place of Palestine except for Tel Aviv. Essentially, if you wanted to have a partition that respected the distribution of populations in Palestine, you could have had a Jewish city-state in Tel Aviv, but clearly the Zionists would not have been satisfied with anything like that. Right? So let's look more at a higher level of the demographics of the proposed partition. So, just by the way, in case you don't know, the partition plan proposed to give the Jewish state, I think it was essentially 62% of the territory of Palestine and something like 37% to the Arabs, and the remaining part would be the city of Jerusalem, what was known as the corpus separatum, a separate city that Jerusalem would be internationalized. Now, even that distribution of Palestine was even more unfair than the number communicates, because the 62% of Palestine that would have been allocated to the Jewish state was the most fertile and most developed part of Palestine. The part of Palestine that would be left for the Arabs was sort of what today is called the West Bank, which is largely uninhabitable and non-arable, right? Okay. Now, what would the proposed demographics of the partition have resulted in? The Jewish state in 1947 had 498,000 Jews, 407,000 Arabs, and 90,000 Bedouins. For some reason, they didn't want to count the Bedouins as Arabs. But if you add the Bedouins to the Arabs, you realize that the plan was crazy because there would be 498,000 Jews and 497,000 Arabs. Now, the plan anticipated arrival of another 150,000 Jews, right? So that would have given the Jewish state a slight Jewish majority, right? Like by maybe there would have been like a 60-40 split population-wise, perhaps, something like that. The Arab state, by contrast, would have been overwhelmingly Arab, 725,000 Arabs and only 10,000 Jews. So you notice it would have been smaller in population and smaller in territory. And then finally, the city of Jerusalem would have 100,000 Jews and 105,000 Arabs for 205,000 total people, right? So the city of Jerusalem would have been much smaller than the district of Jerusalem, and the result would have been basically an equal 50-50 split in population. The Arab state was recognized to be economically unviable. So the UN Special Committee on Palestine that recommended partition understood that it would not be economically viable, and so they also the plan provided for something known as an economic union, which I'll get to shortly. Okay, so the UN General Assembly Resolution 181, as it's called, is passed, 33 in favor, 13 against, with 10 states abstaining, including Great Britain. Now, the fact that Great Britain abstained is very important because Great Britain was the mandatory power. If Great Britain had agreed to the partition plan, that would have been the end of everything, because then it would have had the force, the imprimatur of the mandate for Palestine. But Great Britain refused to endorse it because it recognized it as grossly unfair. Right? So imagine that. Great Britain, imperial power, recognized the partition plan to be grossly unfair and refused to endorse it. Why? Because, as I said, 60% of Palestine given to the Jewish state, only 40% to the Arab state. The most productive lands were given to the Jewish state. But this is very important. The partition plan did not simply draw lines in the so-called sand. It also had substantive requirements. It required the Jewish state, as well as the Arab state, to adopt a liberal constitution with minority rights. It prohibited taking of private property without a public purpose, due process, and prompt compensation. In other words, you couldn't confiscate somebody's property and then pay them later. You had to bring a legal proceeding before a neutral judge who would determine that there was a proper public process for the expropriation, and then the government had to pay fair market value, right? It also provided for, as I said, an economic union, because the majority understood that the Arab state would not be economically viable without a strong economic relationship with the Jewish state, including transfer of tax revenues from the Jewish state to the Arab state. Now, again, economic unions in the best of circumstances are very difficult to carry out. The EU is an example of a very successful economic union. It's hard to imagine how an economic union could have succeeded between this proposed Jewish state and the proposed Arab state, given Zionist demands, right? Finally, and this was another very important point of failure for the partition plan, it didn't provide for any kind of democratic legitimacy. There was no provision for a referendum to approve or reject the proposed partition, thus representing a gross violation of the rights of Palestine citizens to self-determination. Now, I want to look a little bit further into this idea. Did the partition plan actually endorse the idea of a Jewish state? If you look at it closely, in fact, it did not. So as I already mentioned, it required the Jewish state and the Arab state to meet certain minimums with respect to liberal government, right? To have a liberal constitution, etc. Now, before they could draft a constitution, they had to have a constituent assembly. In other words, a group of people designated to draft the constitution. Now, according to the terms of the plan, there had to be a general election to vote for the representative who were going to serve on the constituent assembly. Now, according to the proposal, everybody would get to vote, all citizens of Palestine, whether Arab or Jew. Okay? Now, if you recall the demographics, there were 498,000 Jews, 497,000 Arabs. So it's hard to imagine that if democratic procedures had been followed within the Jewish state, that you would end up with a Zionist constituent assembly, right? Now, according to the UN plan, the Constitution would have to include written guarantees of equal civil, political, and religious rights. It would have to guarantee freedom of movement within Palestine between the two states. It would have to prohibit expropriation of land. And then it also has this important default provision that if a state fails to fulfill the conditions of the plan, then the General Assembly will reconvene to determine what to do. Nothing in the plan authorized anyone to use force to create its own state, much less to do what Israel did in the subsequent year and a half. Okay? So now I want to talk about the creation of the state of Israel. Now, I'm talking about Israel here as something known as a de facto state. So in international law, we make a distinction between a de facto state and a de jure state. A de jure state comes into existence through some lawful means. So the state of Palestine was a de jure state because it came into existence by virtue of international agreements between Turkey and the Allied powers at the end of World War I and the Covenant of the League of Nations. Israel, as I just explained, cannot be explained as coming into existence by virtue of the 1947 partition plan, which the mandatory power never adopted, right? And it was passed by the UN merely as a recommendation, not as a binding law. Right? However, there's another way a state can come into existence, and that's through sort of empirical existence, through satisfying something known as the Montevideo factors. These go to the effectiveness of an entity, right? And there are four factors: a permanent population, a defined territory, a government, and capacity to enter into relations with other states. So Israel came into existence because of its superior arms. Because of its superior arms, it was able to establish these various factors on the ground, what sometimes people call facts on the ground. So that's how Israel became a state. Okay. And so the question here is, was the use of force of arms on the part of Jews in Palestine, was that lawful, right? So Israelis say that we had a right of self-determination, that we Jews have a right of self-determination. And that's on that basis, we could do what we did, right? It was lawful. But there are rules in international law about self-determination. So self-determination there are two different kinds of self-determination historically. One is positive international law, meaning treaties in international law. And the second is customary international law. At the end of World War I, there was no customary international right of self-determination. The evidence for that is the existence of empires, right? So, and so there was no right to self-determination in customary international law in 1919. However, the Palestinians had a positive right to international law by virtue of treaties, right? And the right of self-determination in subsequent years has become a part of customary international law. In fact, a peremptory norm of customary international law, meaning a norm that cannot be violated, right? And so what started as a right recognized only in treaties has now become a universal norm that no state has a right to refuse. Now, what about a group? Does a group have a right to self-determination? And does that give that a right, for example, to secede from another state, because we said that Palestine at the end of World War I was a de jure state. And so one could say that the Jews in Palestine seceded from Palestine, right? Well, there are rules about secession and self-determination, because secession could violate the self-determination rights of the non-seceding group. And so one of the leading cases about secession and international law is courtesy of our own Supreme Court in Canada. This is a 1998 case called the Quebec Secession Reference Case. So in that case, the Supreme Court distinguished between two kinds of self-determination: internal self-determination versus external self-determination. Internal self-determination is essentially the right to be an equal citizen. Okay? So the court said that in the normal case, right, people, groups exercise their self-determination rights as part of being citizens of a country. So when a country offers equal rights to its citizens and affords them every opportunity that it provides the majority and doesn't segregate them, doesn't oppress them, then their rights of self-determination are fully satisfied, right? And so applying that principle to Quebec, they said the Quebecois enjoy full rights of internal self-determination, right? And this is important because if you enjoy the rights of internal self-determination, you don't have the right of external self-determination. External self-determination is the right to secede from an already existing state and become a new state in international law. External self-determination is that right of a group to secede from an already existing state and become a new state. Now, you might ask, why don't groups have a right to secede? Because if they enjoy the rights of internal self-determination, then by seceding, they are acting against the rights of self-determination of the inhabitants of that state. Okay, so external self-determination, except in the case of colonized peoples, is highly disfavored in international law. That's why the Quebecois, the Acadians, don't have a unilateral right to secede. Okay, so minorities just don't have a right to secede as long as certain minimal rights of equal citizenship are being given to them. Now, obviously, that was the case for the Quebecois. I want to return to the question of Jews in Palestine shortly. Now, the Supreme Court of Canada also said that we have to distinguish between de facto effectiveness versus a de jure right of self-determination. So the distinction between internal and external self-determination, that's a matter of de jure public international law. But there is this question of effectiveness. So if you imagine a scenario in which the Quebecois launched an armed rebellion against Canada, managed to seize power in Quebec, drive out all forces of the federal government, it might well be the case that they satisfy the Montevideo conditions. And at some point in time, other states would recognize it, right? So in certain cases, unilateral secession, even though illegal, may result ex post in recognition through this principle of effectiveness. But this is the important part that the court says. This does not support the more radical contention that subsequent recognition of a state of affairs brought about by a unilateral declaration of independence could be taken to mean that secession was achieved under color of a legal right. In other words, even assuming that a state comes into existence by the de facto means of effectiveness, that does not ex post make lawful what it had done in order to achieve that independence, right? And that principle, I think, is very important to understanding the status of Israel and what it has done under international law. Now, I want to contrast the international law version of self-determination with Ben-Gurion's view. Ben-Gurion is the first prime minister of Israel, and he led the Jewish community in the Mandate period, known as the Yishuv, right? What his view was. His view was clearly based on an idea of Jewish supremacy in Palestine. So he said, there are certain rights of self-determination, and when I say the right of the Jew to come back to his country, i.e. Palestine, and the right of our people to be here as equal partners in the world family, it is an overriding a right which applies to Palestine. And therefore, no regime, not only an Arab state, should be created, even no trusteeship, no mandate should be created, which will make that right impossible of realization. That is why we oppose it, immediate application of self-determination in Palestine. It can be safeguarded only if there is independence and the Jews are in the majority. So in other words, what the Zionists were asking for was that the rights of Arabs in Palestine to self-determine be deferred indefinitely until such time as Jewish supremacy could be achieved, right? And in Ben-Gurion's mind, that required a 4-to-1 majority. Okay. Now, this view that self-determination was a privilege of only certain people is consistent with, what others have called colonial international law, based on an idea of civilizational hierarchy. So this view, which was predominant in the 19th century and the first half of the 20th century, essentially said that only white Europeans had the right of self-determination. And we see this reflected in debates about Palestine, even though the UN Charter rejected this idea. So I'm just going to read the highlighted language of statements by the Guatemalan representative to the United Nations Special Committee on Palestine. He said, the Jews had made a pleasant and healthy country out of a land in which a sparse and rachitic population had merely vegetated. If you don't know what rachitic means, don't be embarrassed. I didn't either. It means prone to rickets, right? Essentially diseased. It was incomprehensible that the Arabs should adduce their numerical superiority as an argument when it was the Jews who had made the increase in the Arab population possible. The Arab population, with its simple religiousness and rudimentary political sense, would harm the Jews. An ignorant majority should not be allowed to impose its will. There was a certain order in the world which helped to maintain the necessary equilibrium. If the United Nations wished to save that order, it must consolidate, right? So here you have just a flat-out colonial argument in favor of depriving Palestine's majority of their rights to self-determination that were guaranteed under treaties of international law. But this wasn't limited to this attitude was not limited to the Guatemalan representative. So, for example, Hirsch Lauterpacht, who was celebrated as a great liberal international lawyer, wrote a text in 1945 called the International Bill of the Rights of Man. This text is still celebrated by liberal lawyers as the primary inspiration for the Universal Declaration of Human Rights and the Universal Convention on Human Rights. In that text, Lauterpacht makes clear his position that it is not realistic to view view equality rights as connoting racial equality in all contexts. Nor should an international Bill of Rights require equality of suffrage, for example. For Lauterpacht, quote, the disenfranchisement, partial or total, of large sections of the Negro population in the United States or in South Africa, or of Indians in Kenya and South Africa, unquote, is a matter that should be left to the discretion of the governments concerned. Lauterpacht makes clear that this is because of the implications that equality would entail. In the case of apartheid South Africa, for example, it would be, quote, a consummation which would signify the end of her Western civilization, unquote. In the Union of South Africa, the population of European descent numbers 2 million. The native Bantu populations number 6.5 million. That of colored and Asiatic races, 1 million. The implications in this case of an absolute equality of franchise need no elaboration, unquote. In other words, he said that in order to preserve European privilege and white privilege, it was okay to continue to deny equality to colored peoples. Apartheid, he suggests, along with segregation in parts of the United States or colonial administration in Kenya, quote, is sui generis, and it would be fatal to adapt fully the fundamental purposes of the Bill of Rights to exceptional situations of this nature. And so this attitude was very common, that we can profess equality, we can make statements about the equality of mankind, etc., but we don't really take it seriously in situations where white people have to live with non-whites. In those situations, exceptional situations, sui generis situations, it's okay to impose legal regimes of inequality. Okay. Now, what did Israel actually say in its Declaration of Independence? So it said, members of the People's Council, representatives of the Jewish community of the Eretz Israel and of the Zionist movement, by virtue of our natural and historic right, and on the strength of the resolution of the United Nations General Assembly, hereby declare the establishment of a Jewish state in Eretz Israel to be known as the State of Israel. Now, what I want to point out here is that it nods to the UN resolution, but in fact, it really grounds its claim in what's so-called natural and historic right, right? What the Israelis are saying here is that we have a natural right to Palestine that doesn't depend on the system of international law, right? And this, I think, explains a lot of how Israel behaves, that they believe because of this natural entitlement that they don't need to worry about international law. Now, the Nakba is not simply a tragedy of civil strife or conflict. No, the Nakba was an enabling condition of Israeli independence. It's important to realize that before Israel declared independence on May 12, 1948, right, it had already expelled 350,000 Arabs. In other words, it would not have been able to call itself a Jewish state, but for the Nakba. The Nakba was the process. It was not an incident. It wasn't an unfortunate side effect. It was actually the precondition for the kind of Jewish state that Ben-Gurion wanted, because as I said, he believed that he needed to have an 80% Jewish majority, right? The fighting that broke out after the 1947 partition resolution resulted in 750,000 Arab refugees. And as I said, half of them were before Israel declared independence. In the wake of the forced expulsion of the Palestinian refugees, the Israelis set about confiscating all their property. Peter Beinart wrote the following: the scale of the land theft was astonishing. When the United Nations passed its partition plan in November 1947, Jews owned roughly 7% of the territory of mandatory Palestine. By the early 1950s, almost 95% of Israel's land was owned by the Jewish state. All of this was in violation of international law. Again, going back to the Hague Conventions. The authority of the legitimate power having in fact passed into the hands of the occupant, the latter shall take all the measures in his power to restore and ensure as far as possible public order and safety, while respecting, unless absolutely prevented, the laws enforced in the country. So if we were to take the partition plan as the basis of Israel's legitimacy, then the territory that it acquired outside of the partition should be deemed occupied territory. It should have acted to reinstate law and order instead of inciting people to flee, which it did, right? Article 46 requires parties to respect family honor and rights, lives of persons and private property. It says explicitly, private property cannot be confiscated. That was not respected, right? Palestinian land was confiscated and given to Jews. Likewise, pillage is formally forbidden. Pillage is the term of art in military law, in which combatants take the personal property of the enemy, right? Again, that is forbidden, but that didn't stop the Zionists from invading Palestinian homes, taking their personal property and giving it and redistributing it among themselves, something that we see being practiced by Israeli soldiers today in Gaza. The Nakba was not simply physical violence. It was also a regime of legal violence. And this legal violence manifested itself most clearly in stripping Palestinians of their citizenship. As you recall, I started off my presentation talking about the principle of ipso facto nationality. So even assuming that Israel became a sovereign over all the territory that it acquired in the fighting in 1948, that would mean that the former Palestinian citizens of those territories should have become ipso facto Israeli citizens. But that was not the case. Israel passed a law, the so-called nationality law, which is really a citizenship law. But according to that law, if you had been expelled from the territories that became Israel, i.e., if you were not on Israel as of a certain date, physically present, you lost your citizenship. You could not become a citizenship of Israel, right? And then this was reinforced in a series of cases in a series of early cases in Israel, which effectively stated that with the end of the Palestine Mandate, Palestinian citizenship disappeared. So these early cases rejected ipso facto citizenship in violation of fundamental principles of public international law. Indeed, there's this one Israeli case that tried to say that no, we have to admit the principle of ipso facto citizenship because otherwise there would be an absurdity because we declared a state in 1948, but we didn't pass a nationality law in 1950. So if it were true that the principle of ipso facto citizenship doesn't apply, that would mean the state of Israel existed without citizens for 2 years, which would be a legal absurdity. But again, that didn't stop Israeli courts from repudiating their obligations under international law to extend citizenship to Palestinians. Right? Now, why is this significant? Because the argument that I'm saying is that Palestinians are, by virtue of principles of public international law, citizens by right of Israel, which means Israel has an obligation to allow them to return. Because a state in international law has an obligation to allow its citizens to come back. Just like Canada has an obligation to admit me since I'm a Canadian citizen, Israel also has an obligation to allow Arab refugees to return. Okay. Well, what about Israel becoming a member of the United Nations? Does that change things? Israel eventually became a member of the United Nations in 1949. And so does this give it de jure statehood? Well, maybe, because when the United Nations admitted Israel as a state, it did so conditionally, because it required Israel to unreservedly accept the obligations of the UN Charter and undertake to honor them from the day it becomes a member. And it explicitly required Israel to recognize 2 resolutions of the General Assembly, the partition plan and the 194, I believe, is UN General, United Nations General Assembly Resolution 194, which explicitly requires the return of refugees, right? And so Israel's representatives to the General Assembly stated that Israel would honor these resolutions in good faith. And so it admitted Israel with those caveats on the assumption that Israel in good faith would implement those resolutions, which of course it has not done. Right? Now, one final question. Did Palestine come to an end with the end of the mandate? A lot of people say this, that when Britain abandoned its role as the mandatory power, that meant that the mandate had come to an end, right? And the only thing that matters is facts on the ground. So Palestine fails to satisfy the Montevideo factors, and so therefore it is not a state, right? I think that's a very erroneous argument under public international law for several reasons. The first is when Great Britain abandoned the mandate, the United Nations did not do anything to terminate the mandate. So the mandate continued in existence. And that's evidenced by the fact that it continued on the agenda of the United Nations as the question of Palestine, right? The Charter of the United Nations does not provide for any mechanism for a mandate to come to an end except through one of 2 means. The first is that the state that is subject to the mandate becomes independent. That hasn't happened with Palestine. Or it becomes subject to a trusteeship. It has no provision for the idea that a mandate can be terminated through destruction. Right? And then this is further confirmed by the rules that govern the International Court of Justice, which is a mandatory institution of the UN system. So it says the general principles of law recognized by civilized nations is one of the sources of international law. Now, as I said, the mandate for Palestine was considered a trust, a sacred trust of civilization that the mandatory power of Great Britain and then the League of Nations and then the United Nations and successor owed to the inhabitants of Palestine. One of the bedrock principles of trust law is that no trust fails for a want of a trustee. Just because a trustee abandons his duty as trustee does not mean that the trust comes to an end. Rather, a new trustee has to be appointed. And so for that reason, I would say that those of us who are Palestine advocates demanding Palestinian independence, Palestinian freedom, we are undertaking an obligation recognized at the beginning of the 20th century as the sacred trust of civilizations, namely the independence of Palestine. Thank you.
Thank you so much, Dr. Fadl. Um, was there anyone that had any questions? I did actually have one question for you, Dr. Fadl, if that's okay.
Of course, we have half an hour for questions.
Um, so I was wondering, because in the beginning you had spoken about um, just kind of that transition between the British Mandate of Palestine uh, to Israel. Where does the Sykes-Picot Agreement fit in there, or does it fit in there at all? Do I have my dates mixed up?
The Sykes-Picot Agreement was during World War I. This was a secret agreement between Great Britain and France to divide up the Arabic-speaking provinces of the Ottoman Empire, right? So
Okay.
presumably their initial plan was to divide them up and make them colonies. But in order to induce the United States to enter World War I on their side, they basically had to agree that they weren't going to colonize these territories, right? So I mentioned that Woodrow Wilson insisted that the former Ottoman territories enjoy self-determination. And that was explicitly recognized in the Treaty of Versailles in the Covenant of the League of Nations, right? And so that's why instead of them being colonies subject to direct colonial rule of Great Britain and France, they were made mandates. So a mandate is like this trust arrangement,
Mm-hmm.
in which France and Great Britain could not rule as sovereigns. They had to rule as administrators, as trustees for the benefit of the inhabitants. And as I said, they all gained their independence relatively quickly.
Mm-hmm.
Just like the Covenant of League of Nations required. It said that the provisional independence, recognition of their provisional independence as nations could be recognized, subject only to technical assistance, right? So
I see.
Sykes-Picot was important in drawing the boundaries among the post-Ottoman Arab states, but
Okay.
it didn't end up creating legal colonies. I mean, some people say, what's the difference between a mandate and a colony? Maybe there wasn't a practical difference, but in international law, there was an important difference.
I see. Okay. Um, so you said the Sykes-Picot Agreement served to divide the Arab colonies, as you
No,
said.
not Arab colonies, the
Oh,
Arab
sorry.
provinces of the
Sorry.
Ottoman.
Sorry. Pardon me. Arab provinces. Um, okay. And you said those were sorry. What was the word that you had used?
Mandates. Mandate.
Mandates. Okay. 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 Thank you. That's the only question I had. If anybody else has questions,
The
go ahead.
important point is that their provisional independence, the right to independence, was guaranteed as a part of the settlement of World War
Okay. Sorry, I'm going to put that in my notes just because I was taking notes um, throughout the session. Um, did anybody else have any other questions at all? Mm, oh, I think there's some in the chat. Okay. So,
Yeah,
Rebecca, uh,
I'll read the question.
okay, go
If
ahead.
Israel has yet to meet the conditions of their joining the UN, what is keeping them in the United Nations? Who keeps countries accountable to their conditions of membership? Excellent question. In theory, um, countries in the UN could move to have Israel expelled for its unceasing lawbreaking, right? Um, of course, part of the problem is the United States will come to its defense. However, I recently read a report by an Israeli international jurist who is in favor of kicking Israel out of the UN, suggesting how it could be done in a way that doesn't depend on the United States consent. It's a procedural maneuver that has to do with the Credentials Committee. I can't tell you all the technicalities, but there could be a way to do it. But as is the case generally with international law, it requires political will to do so. And this is why I emphasize it's so important for advocates for Palestine to keep up pressure on elected politicians, because international law, in the absence of domestic pressure, is very weak. If you really want to understand why Zionism has succeeded despite its illegality, is that it is highly organized in the centers of power, whereas the voices for Palestine are not. And so even though Palestine has right on its side, it does not have the ears of politicians in the centers of power, sadly.
Hi, thank you so much for your response. There's been a lot in this presentation, and like Janine, I also have a lot of notes. I think one question I have for you is just, do you have any tips for staying calm when you're having an argument with a Zionist? Like, how do you argue
My,
with someone who
my
doesn't?
view is never argue with a Zionist,
Yeah.
because no, because I'm honest, because um, Zionists don't care about truth, they don't care about facts. What you need to do is talk to normal people, because they're the people, normal people, who are basically good, but they have a lot of other things going on in their lives and they can't focus, right? And so we need to explain to them the the horrific nature of this project, because they're the ones that can be convinced. You know, Zionists are inconvincible. They're in a, you know, and so there's no point in debating with Zionists.
If anyone has any other questions, go ahead.
I feel bad. Maybe it was too technical.
No, I don't think that at all. I think you had a lot of valuable information, and you definitely gave a perspective that I never really considered, which I felt was more of like the legal side of things. I feel like oftentimes when we talk about Palestine, it's kind of very informal. So this was, I felt this was great.
Again, going back to debating with Zionists, one common talking point, I mean, it's insane, but they say it all the time. There's no such thing as Palestine. Um, I systematically showed that Palestine existed as a legal entity, right? And if there's one core principle of modern international law is that you cannot destroy an international legal person by violence. That's what the Kellogg-Briand Pact is all about. That's what supposedly makes our international law different than what came before. Zionism, what it wants to do is take us back to the 19th century when might makes right. Um, I gave Janine the slide so she can share it with you guys if you want it. Okay, I don't want to force you guys to stick around if you don't have any more questions.
I think maybe some folks in the chat, maybe they're fasting or something, and yeah, maybe they're just taking it all in. Maybe, yeah. Oh, says CJ had a follow up question in that question. Um, oh,
Oh,
uh, okay.
books. There's so many books. um, if you're interested in sort of the legal dimension, I'm going to put it in the chat. So a fellow named Victor Catan, I think it's called From Refuge to Conquest or something like that. From Safe Haven to Conquest. I'm not sure of the title, but the author, Victor Catan, K-A-T-T-A-N, he's very good. Um, so, and his book is very readable and very accessible and very well researched. So that's a great go-to source, right? Where can you find me online? I have a Facebook page, which is completely open. So if you look up my name, you'll find my Facebook wall. I don't necessarily accept friendship requests because I think I'm at the limit, but it's an unrestricted wall, so anybody can view my Facebook page. And I used to have a Twitter account, but I've been hijacked and locked out of it. I'm still trying to get into it. But I also am on Blue Sky. I'm on Blue Sky, and my handle is Shanfara. And I'm on Threads. There. And I also just joined Upscroll, if anybody knows that. It's a Palestinian-made social media thing. I don't post so much on Upscroll yet, though. And I also go by Shanfara there as well.
I see Heather had a question. Given years of failure of international community to challenge Israel, what is the most effective means for us as the international community to respond?
Great question. Lots of times when I talk about law, my remarks are received with a great deal of cynicism, and I understand why. But let me assure you that the Zionists would really like us to forget about international law. If international law were meaningless, they wouldn't be screaming at all the cases that are being brought against Israel, right? So I think there are lots of things that we can do as Canadians to get our government to enforce international law. As I said, international law depends on its enforcement on states. States have to be willing to enforce it. Now, as it turns out, a lot of international law is incorporated into domestic legal systems. So, for example, many international commitments of Canada are now part of Canadian domestic law. So there's an international convention prohibiting genocide. Well, we have a similar provision in Canadian criminal law, right? So there are lots of provisions within Canadian criminal law that we can use to pressure the government to bring actions against, for example, Canadians who go fight in Israel, or manufacturers of weapons selling things to Israel. So there's still lots of tools that the law gives us to allow us to challenge Israel indirectly, right? And that's what lots of international lawyers are doing. And yes, it hasn't reached its final goal yet. But if it were meaningless, you wouldn't see the kinds of um, unhinged responses that Zionists have to Palestinians and Palestinian advocates using international law against them, right? And so my perspective on this, and maybe I'm a bit naive, but I think you have to be to fight this. I've been doing this since I was 11 years old. If you've ever walked out, you guys are Albertans, you've walked out on ice fields, you've gone to glaciers, you know that ice breaks suddenly, all at once. It doesn't, you can't tell when it's from the outside, when it's weakened, sufficiently weakened that it just collapses. So that's my view of Zionism. It looks so strong, but it's weak because it's based on violence. It's based on lies. It's based on falsehood. And at some point in time, it's going to crack. And when it cracks, the whole thing is going to come tumbling down. So everything about it is contrary to everything that we as humanity have worked for in the last 100 years. And so you have to maintain that in your hearts to keep you hopeful. Rebecca, you said that Palestine was the only mandated state that didn't receive independence prior to World War II. Yeah, the difference was Zionism. Like, how come Palestine, of all the post-Ottoman states, didn't attain independence? It was because of Zionism. I gave you the quote from Ben-Gurion. The Zionists refused to cooperate in allowing Palestine to become independent, contrary to the terms of the Palestine Mandate, right?
No, that was a perfect analogy, Dr. Fadal. I've never really considered that. Like, I think sometimes these empires seem so strong, but I think like yeah, how you put it is like when we walk on an ice field, we never know like if we're just gonna fall right through or just how strong it is, and it is built on violence, so it's only gonna be so sustainable to survive for sure.
Now, let me give you one other book. Oh, did Rebecca have another question? Okay. Um,
Yeah, I think if no one else has any questions, I guess we could just let you go, Dr. Fadl. Thank you so much for
that was
taking the time on, on a Saturday in Ramadan. We really greatly appreciate it. And I also wanted to thank everybody else who joined for taking the time to educate yourself. That's so important when we're talking about Palestine. Is we really need to know uh, what we're fighting, what we're fighting for, and we need to know about Palestine and its history. Um, so yeah, thank you so much, Dr. Fadl. Yeah, just one more time, if anyone has any questions. If not, I'll just end the. Yes, round of applause for Dr. Fadl. Yes, thank you so much.
okay.
Thank you.
Okay.
Um,
My pleasure.
all right, thank you so much, Dr. Fadl.
Okay. Take care. Bye.